of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to this December session of the Tennessee Court of Criminal Appeals. For the first time, we are Zooming our oral arguments on live stream on the internet by way of YouTube, and you can check us out on 10courts. It's just 10 Courts channel on YouTube. We wish to thank the lawyers appearing today and their willingness to help us use this new technology. Clerk Jim Hibner and his staff, the staff of the ALC for making all of this possible. We prefer to be in person and have hearings, but we're attempting to help with a solution to the spread of COVID. And by using this technology, perhaps we in some way minimize the possibility of its spread. And this also allows us to keep our cases moving in a timely fashion. The judges that are appearing here with me today are Judge Ross Dyer from Memphis, Shelby County, Tennessee, Judge Camille McMullen from Memphis, Shelby County, Tennessee, and I'm presiding Judge John Everett Williams from Huntington, Carroll County, Tennessee. We are all delighted to have you here with us today. The cases today will proceed in the same manner that they do on in-person hearings. Each side is given 20 minutes to address the court. The appellant may reserve time for rebuttal argument. Should you wish to ask for rebuttal argument, please do so upon introducing yourself to the court, and I will help you keep your time and tell you when you're approaching your rebuttal time argument. With that, Madam Clerk, if there's no other preliminary matters, would you please call the first case?
State of Tennessee versus Torijon Coplin.
The appellant's time starts now. Thank you.
Thank you, Your Honor. This is Brennan Wingirter with the Appellate Division of the Public Defender's Conference here on behalf of Mr. Torijon Coplin. With the court's permission, I'd like to reserve 2 minutes for rebuttal.
Yes, ma'am.
Thank you, Your Honor. This is a case about essentially a mutual combat, a shootout between the occupants of 2 different vehicles. My client, Mr. Coplin, was driving a silver Nissan Altima. His passenger was a gentleman named Mr. Manning. Mr. Coplin and Mr. Manning were traveling and behind a Dodge Charger. That Charger was driven by a man named Mr. Anderson. It is undisputed that Mr. Anderson had a gun and that Mr. Manning had a gun. And it is undisputed that they fired shots at each other towards their respective vehicles. Mr. Coplin was not shown on the video of the shooting as having a gun. But nevertheless, it was undisputed that there was a gun with Mr. Anderson and a gun with Mr. Manning. They admitted to that. All 3 of those men fled the scene of the shooting. And Mr. Manning and Mr. Anderson both admitted that they discarded their weapons before they were located by police. Now, Mr. Anderson was ultimately deemed to be the victim in this case, and Mr. Manning and Mr. Coplin were both charged with aggravated assault and tampering with evidence. They were both found guilty after a jury trial, and this was a joint trial. Mr. Manning testified, but Mr. Coplin did not. We are asking this court to reverse Mr. Coplin's 2 convictions for lack of sufficient evidence of either the aggravated assault or the tampering. Now, both of these convictions turn on the answers to 2 questions. Number 1, who had a gun? And number 2, who fired the first shot? Now, as I said, it was undisputed that Mr. Manning and Mr. Anderson each had a weapon. They admitted to that.
Counsel, didn't the victim say that your client shot him?
Mr. Anderson testified that my client, Mr. Coplin, shot at him. However, that testimony is not supported by any of the objective video evidence in the record. And Mr. Anderson admitted multiple times at trial that his version of events was not supported by the video evidence. The state
testified that your client shot him. He clearly said your client shot at him.
Yes, that is correct. Mr. Anderson said that Mr. Coplin shot at him.
Well, you know what my next question is. I mean, the jury, you know where I'm going with this. The jury resolves all those credibility issues. And we don't second guess the jury when it comes to those matters.
That's right, Your Honor. But our position is that that would be the case if there was no video of the shooting. But we actually have.
And the video, based on your brief, both your brief and the state's brief, is not clear.
It is clear enough that you can determine that only Mr. Manning and Mr. Anderson are shooting towards each other. It is clear enough that you can determine that Mr. Anderson's statement that Mr. Coplin got out of the driver's side car and shot at him did not happen. That much is certainly clear from the video. And Mr. Anderson admitted that the video did not show Mr. Coplin getting out of the car and shooting at him as he had claimed. So our position is if this video did not exist, then we have a closer case on credibility. But with the video,
I don't want to leave that question just yet. Did the victim state that your client never shot him? I mean, I understand that this happened over the course of a minute, 2 minute, 3 minute time span. And I understand that we only have a snippet on the video. But did the victim actually at any point during the trial testify that your client never shot him?
He did not say that Mr. Coplin never shot him. He said, I double checked the testimony this morning just to be sure I was clear. He said they shot at me. And when he was talking about Mr. Coplin specifically, it was where he said that Mr. Coplin got out of the driver's side door and shot at him, which is not, and he admitted that is not what is shown on the video. He also said, look, they're shooting at me. Maybe I didn't remember perfectly. And that, again, that goes to our point that how does he know beyond a reasonable doubt that it was Mr. Coplin who fired at him when we have the co-defendant, Mr. Manning, admitting that he had a gun and admitting that he did shoot at Mr. Anderson. So our position is that the video, coupled with the state's concession that Mr. Anderson has credibility problems, that because of the video and because of the multiple admissions by Mr. Anderson, that his version was not supported by the other evidence and the lack of.
Let me ask this. I kind of want to ask a question that Judge McMullen kind of touched on just a second ago. How much of this incident is actually captured on the video? I mean, I'm sure the testimony varies as to how long it lasted, but I mean, your best summation of how long did it last and how much of it is actually on video?
So the video clip itself, which has no audio, by the way, is 30 seconds. So the video of 30 seconds shows Mr. Anderson's Dodge Charger stop in the middle of the street. You see Mr. Anderson get out of the car. You see him firing towards the silver Altima that's behind him. Mr. Coplin is driving that Altima, and you can see Mr. Manning, his passenger, sort of leaning out of the passenger side window door area, shooting back at Mr. Anderson. All of that transpires in those 30 seconds.
Well, but if I understood, and maybe I didn't, but as I understood in reading the briefs, at least that the victim claims that the shooting started before the cars ever stopped. Is that correct?
That's correct, Your Honor. He claimed that they were shooting at him while they were driving. And again, this goes to, can a rational juror conclude beyond a reasonable doubt that Mr. Coplin, while driving, is shooting at Mr. Anderson when there is no proof that Mr. Coplin ever even had a gun at all? And when Mr. Manning testifies that he was the only one in that vehicle who had a gun, and that he, Mr. Manning, was the only one who was firing that gun towards Mr. Anderson. That's
well, let me ask you that one more question on that. Did Mr. Manning testify, I'm the only one that had a gun and I'm the only one that shot? Or did he just say, I had a gun and I shot?
He testified that there was one gun in that car and that he was the one who shot back at Mr. Anderson. According to Mr. Manning, it was after Mr. Anderson started shooting at him. But he does say that he was the one who shot and that there was one gun in that vehicle. And that goes to not only the self-defense issue, which is that second question I mentioned of who fired first, but more importantly, I think in our position, as far as Mr. Coplin is concerned, it goes to the tampering conviction of what was the evidence that was supposedly being tampered with. So the state, the prosecutor at trial, when asked what evidence was tampered with, said at least one firearm. And that's a direct quote, because the state never proved that there was more than one gun in the Coplin Manning vehicle. And again, Mr. Manning admitted that that gun was the one that he used. And there was never any proof that Mr. Coplin possessed a second gun. The state in this appeal, I want to be very clear that we are talking about a difference between whether Mr. Coplin was a principal actor in these offenses or whether he was found guilty through a theory of criminal responsibility. The state in its brief has only argued that Mr. Coplin was a principal actor of both offenses. They have put all their eggs in one basket that Mr. Coplin did have a second gun, that Mr. Coplin fired that gun, that Mr. Coplin was the first person out of all three of these people to fire his gun, and that Mr. Coplin concealed or tampered with that gun between the time of the shooting and the time of his arrest. Our position is the problem with the state's argument is there's no proof that that second gun ever even existed. And so when we look at what the state did show here for the tampering conviction, this court has to look at the State v. Hawkins case out of the Tennessee Supreme Court. And again, I will point out, the state did not even cite Hawkins in its brief. They did not address Hawkins at all. And whether we're talking about Mr. Coplin being a principal actor or under a theory of criminal responsibility, Hawkins has to be addressed because we're asking whether the disposal of Mr. Manning's gun, and even if this court finds that there was a second gun, then by extension, the second gun, which again was not proven to exist. When we're asking what happened to Mr. Manning's gun, the question is, did Mr. Manning have the specific intent, tampering is a specific intent crime, to conceal that weapon, to put it out of sight, to prevent its availability as evidence? In Hawkins, the Tennessee
I want to give you enough time to get into Hawkins and the state's failure to cite it at all, but I want to still address your aggravated assault issue. And couldn't the jury have discredited entirely the co-defendant's testimony in regard to self-defense, as well as the fact that your client didn't have a gun? I mean, couldn't they have discredited that and accredited the victim's testimony here? I understand that the victim was asked or cross-examined greatly in regard to this issue. And there was a 911 tape that was played for the jury from top to bottom. The victim called 911 upon seeing your client and the co-defendant following him. And he basically gave the jury a play-by-play with everything that was going on from beginning to end in this offense. So based on that proof, couldn't the jury have just discredited everything that you're saying in regard to the fact that there was no second gun, the fact that the victim was the first aggressor in this case? I mean, all of these are factual issues, which you know full well we don't get into. Those things are resolved by the jury. So can you address that? Because I think your biggest issue in this case is that aggravated assault.
Yes, Your Honor. And I will address that. The way that we address in the brief is that on a self-defense claim, it is a factual issue for the jury to resolve. That is true. But then on appeal, the question is whether, as a matter of law, the state negated the self-defense theory beyond a reasonable doubt. And so that is how we have addressed the aggravated assault, Your Honor, is that beyond the jury's credibility determinations, beyond Mr. Anderson's, as the state has conceded, credibility problems, as a matter of law, could a rational juror have rejected the self-defense theory beyond a reasonable doubt when the only proof, the only testimony of Mr. Manning firing first is Mr. Anderson's testimony? And I understand Your Honor's point that, yes, the jury could, in the face of the 911 call and the video and all of his admissions on cross-examination, the jury can still accredit him. We understand that. That is why, as a matter of law, we're asking for the court to apply that beyond a reasonable doubt standard, because it is the state's burden to negate self-defense at that point. And the state and I have both addressed that standard of review in our briefs.
And address this for me. Did your client raise self-defense? Was the co-defendant that raised the self-defense issue, and were we just kind of bootstrapping on the co-defendant's testimony that?
Right. It was argued in closing argument. It was primarily directed at the co-defendant. That's true, because it was the co-defendant who testified. Again, this gets into, was Mr. Coplin a principal actor, or was it a criminal responsibility finding? And the state has insisted that Mr. Coplin was a principal actor. Our argument is we're looking at criminal responsibility. And when you look at criminal responsibility, we have the plain error in the jury instruction that we raised that the state did not address. And we have the fact that criminal responsibility requires specific intent on the part of Mr. Coplin, which again, the state has not addressed because they say criminal responsibility is irrelevant.
Excuse me. The problem with that is we will never know, will we?
That is the problem with that is, Your Honor.
The juries are given both theories and they can follow either one they wish.
That's correct,
Right.
John. The jury was instructed on criminal responsibility, partially instructed on criminal responsibility in this case.
And without a videotape in this case, there was clearly evidence that the defendant, the victim claimed the defendant fired a gun at him first before he stopped. So all of that would have been transpired outside the purview of the video. And given the jury's role in our judicial process, they control and they say against your client, then that's sufficient evidence to hold that he's guilty of this offense. Is that not correct?
That's correct, which is why, if I have time, I'd like to address that tampering issue, Judge McMullen, that you raised, because if we get to the tampering conviction under Hawkins, whether it's Mr. Coplin as a principal actor or Mr. Manning as the principal actor, the question is the same. Was this concealment or was this mere abandonment? And Hawkins left up.
It's a good time to tell you you're 15 minutes into your argument.
Thank you, Your Honor. For Hawkins, what was left open were three specific questions. Can the abandonment exception apply when it's a non-possessory offense, which is what we have here? Can it apply when the police officers do not personally observe the defendant get rid of whatever the thing is that they think is evidence? That's what we have here. And third, whether the abandonment exception can apply when the police never end up recovering whatever they think is the evidence, as we have here. So this case is exactly what Hawkins identified as the gray area between concealment and abandonment. And here, and I want to make clear that in Hawkins, the guidance that the Supreme Court gave was you have to look at the precise facts of each case. We are not asking this court to extend Hawkins. We're not asking for any kind of broad rule. We're just asking the court, look at this precise facts of this case where we have a shooting on one street and the officers testified that they arrested Manning and Coplin a block over. It was less than 100 yards away within 3 to 10 minutes. So we have a very short distance and a very small window of time. And we have no testimony from the state, no evidence from the state as to where the officers looked at all, other than we searched the residence where we found Mr. Manning's home, which was a block away. So there's no testimony whatsoever of we secured the crime scene, we set up a perimeter, we drove along the route. You can see on the video that Mr. Coplin drives off one way, Mr. Manning drives off another way. There's no testimony that the officers followed those routes to get back to Mr. Manning's residence. And again, we're talking about 3 to 10 minutes and just a block over. So our position is that under these specific facts, that the disposal of the at least one firearm, whether it's one or two, has to be mere abandonment, because otherwise we're upholding a tampering conviction simply based on the absence of evidence that may not have actually existed, without any proof that the officers actually looked for it. In other words, upholding the conviction encourages police officers not to go look for the evidence because they can just secure a tampering conviction by saying, we didn't find anything. And so I'll cede the rest of my time to rebuttal and just ask that the court reverse both of these convictions for lack of sufficient evidence. Thank you.
You have an extra 30 seconds. Thank you, General.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. I'd like to briefly go over the facts before we kind of get into the sufficiency claim. And I'm going to back up a little bit. This all started where the victim, Mr. Anderson, was driving down one side of the road, and he saw driving the other way the defendant and Mr. Manning in the vehicle. He then saw the defendant pull a U-turn and begin following him. And that's when he called 911. He had, I guess you could call it, some bad blood with the defendant. There was an issue with a woman, and he thought that the defendant was out to get him. And so he called 911 and was on the phone with officers telling them, I'm being followed. These people are coming after me. I think they're going to get me. I'm turning onto this road, things of that nature. He then testified that he got shot at, that the defendant shot at him, and that at that point he stopped his car, got out of his car, and began returning fire with his handgun. And he had a handgun carry permit, so he was lawfully carrying, and he began defending himself by firing back. And he testified that the defendant and Mr. Manning both fired shots at him, but that they were unsuccessful in hitting him, and he was able to flee the scene. He then testified that he went and hid in a van for a little while, left his gun in the van, and hid in a house, whereas the defendant and Mr. Manning began to flee the scene. Mr. Manning got out of the defendant's car, entered Mr. Anderson's car, and drove off in one direction. The defendant stayed in his car and drove off in another direction. The proof is that officers showed up, responded to the call of the shooting, and that they set up a perimeter, and they traveled to a nearby house based on a concerned citizen's call. And that's where it was actually Mr. Manning's mother's house, and that's where Mr. Manning and the defendant had hid out. So officers went to that house. They asked the mother to call the defendant and Mr. Manning.
Why do you say they hid out? Why do you say they hid out? He was at his mother's house, came out immediately upon being asked. Careful in mischaracterizing, what happened in this case. Well, they came out immediately upon being asked.
They did come out immediately after being asked, Your Honor, but they did not stay at the scene of the shooting. They fled the scene of the shooting. And so after they had shot at Mr. Anderson, they fled and they went into a house. And they parked the vehicle away at a dead-end street, a house away from where they were staying. And so the jury was entitled to infer that they were attempting to hide from police officers. And once they realized
the reason I went to that is because that speaks or informs the tampering conviction, in my view. So that is why I'm asking you to exercise caution with your words in terms of where the defendants were found. But go ahead, you may proceed with the case.
Yes, Your Honor. And the state submits that the fact that they fled and the fact that they went into a house goes towards their intent to hide or to conceal. And so the facts show that they did that, and that officers not only set up a perimeter, but they found the vehicle, the defendant's vehicle, that they searched that vehicle, and that they searched the house that the defendant and Mr. Manning were in. And so I think when you look at the totality, or when you look at all of that evidence, that's when you get to a sufficiency of the argument.
Did I hear you mention anything about bullet holes in the backs of the car, or what did was the victim's car not riddled with bullet holes?
Very, very much so, Your Honor. Yes, there was testimony that they found Mr. Anderson's car as well, and Mr. Anderson's car had bullet holes riddled across the back. It had gone through the back windshield. Several had gone through the back seat, and I believe one had gone through the front windshield. And there was testimony that those bullets could not have been fired by Mr. Anderson because they were coming from behind the car. And they also, when they searched the defendant's car, they found multiple bullet holes there, including some bullet holes on the trunk that corroborated Mr. Manning's testimony that he fired at the defendant as well. So,
and that is at least a bit of information the jury could conceivably use to say, I know why he got out and ran.
Very much so.
The bullets went through the car.
Especially when you consider, along with Mr. Anderson's testimony, that the reason I stopped my car is because there was a shot that came through it. And he says, I wasn't going to sit there and have them keep shooting at me in this vehicle. I'm going to get out and try and flee. And so,
General Coleman, I want to address something. Maybe it's a housekeeping matter, but defense counsel mentioned the fact that you did not cite Hawkins in your brief. They spent at least 8 or 9 pages analyzing Hawkins and applying Hawkins to this case. what was your rationale for not even citing that case, which appears to be directly on point for the tampering conviction?
Yes, Your Honor. Hawkins simply stands for the proposition that you have to differentiate between mere abandonment and concealment. And so the state focused on the facts here and what established the intent behind the concealment. What proved that the defendants were intentionally concealing their handguns.
Are you answering my question? I'm sorry. When you say you gave this court one sentence in response to the defense brief's 8 pages of analysis on this issue, and that's what you want us to consider in our review of this issue?
Well, Your Honor, again, the state concedes that Hawkins is on point. But again, the proposition it stands for is to simply differentiate between abandonment and concealment. And so the state would submit that this court looks at the facts. Again, Hawkins emphasizes this is a fact-intensive analysis. And so our argument focused on those facts.
Well, what facts support the tampering?
Yes, Your Honor. Several. First, the fact that the defendant fled from the scene. Then you have the proof that police officers did do an investigation. There was testimony as to where police officers looked. And so they set up a perimeter around the scene of the shooting. They searched Mr. Anderson's car. They found the defendant's car and searched the defendant's car. And then they searched the house that the defendant and Mr. Manning were found in.
You're giving me facts that are the same as Hawkins, which was reversed. They reversed the tampering conviction.
So the state can file a supplemental brief on Hawkins if this court would like. We respectfully submit that the facts are different.
Okay.
That there was a little bit more investigation and that there was enough for a jury to determine that there was a difference between mere abandonment and between intentional concealment.
And the other issue that I have, the problem with this case is initially, I guess the state was looking at the car, the fact that the defendant and the co-defendant moved the victim's car as the thing that was tampered with. And then later on, after the issue was addressed by the defense, the state elected to rely on the presence of a second gun as the thing that was tampered with. So defense counsel was kind of in a situation where they didn't know what you were relying on for the thing that was tampered with. So can you speak to that, General?
Yes, Your Honor. And there's no proof at all that the state ever relied on the vehicle. That was the defense counsel's assumption. And so admittedly, the state didn't specify that the 2 guns were what it was focusing on until the issue was brought up in front of the trial court. But the state never informed defense counsel, or at least the record doesn't indicate that the state was informing defense counsel that the car was what was tampered with. Immediately when the state was asked, they said the 2 guns. And later on, they said there's at least 1 gun, but they did tell the judge when they were
discussing. You got a moving target through the trial. You got a moving target. The defense doesn't know how to, what to defend on because you haven't relied on or pointed to what you're relying on. Don't you think that's a problem?
Well, if the defense wanted to determine exactly what it was, they could have asked exactly what it was. And so the state put on its proof and was able to indicate what thing that was being concealed. The indictment would have covered the handguns, and the state discussed that, and that's what the state relied on with the 2 different handguns. And so,
what was the state?
Go ahead. I'm sorry, Judge Dyer. Go ahead.
Well, what was the state's opening argument about? I mean, you're going to hear proof about this is usually what they say, and he's charged with this. And so what did they say as relates to the tampering in their opening statement? Well, I mean, I know it's not evidence, but at least gives us a path of where we're going, right?
Yes, Your Honor. I think the record will speak more accurately on that. I haven't read the opening statements in a while. My recollection is that they overall kind of discussed that both defendants had shot at Mr. Anderson and fled the scene. And I honestly do not remember exactly what they pointed to when they were discussing tampering with the evidence, if they discussed it at all in opening statements. I think my understanding of the opening statement was more that here's what happened, here's what we're going to show you, and not necessarily tying it to specific evidence or specific offenses. But again, the record will be more accurate with that, and this court can look at that for guidance.
So speak to why this gun was concealed rather than abandoned.
Yes, Your Honor, and it goes towards the temporal nature as well as where the police officers looked. The police officers, where it would have been abandoned, police officers could have seen. So it wasn't dropped at the scene of the shooting. It wasn't left inside of the vehicle when the defendant fled his vehicle, and it wasn't in the house where he went into and was ultimately caught. And so when police officers search those different areas, that's an indication, and they can't find the gun. That's an indication.
So what you're telling me, in every case where law enforcement cannot find a piece of evidence, they can thereafter charge the defendant with tampering because they can't find it?
No, Your Honor, I don't. And I think the burden isn't necessarily on the fact that police can or can't find it. The question is...
That's what you just said. You just said that the gun wasn't there, so they couldn't find it.
They couldn't find it in those places, which indicates the defendant's intent to hide it. And so a rational trier of fact could reasonably conclude that the defendant had not simply abandoned his gun, but had hidden it somewhere, not in the normal areas where police officers wouldn't necessarily look or wouldn't necessarily be able to find. It goes to the question.
So are you suggesting that if this arrest would have taken place the next day, tampering would not be an issue in this case?
Not necessarily, Your Honor. I think that starts getting into speculative issues and whether the state would need to put on more proof and things of that nature. But given the facts of this case, the fact that they caught them almost immediately afterwards, and they set up a perimeter, searched this car, did reasonable investigation. It goes to show the defendant's intent. And the question with tampering with the evidence is, did the defendant intend to conceal this? And so,
I added a fact specifically and purposefully to you. If this arrest would have happened the next day, would the state be in a less position than it is today to make the argument of tampering with evidence?
I think if the arrest had been made a day later and there was no additional proof of where officers had looked for the defendants or had any further investigation for 24 hours, then the state would probably be in a less strong position because there are more possibilities of what the defendant could have done, and maybe the defendant could have abandoned it for after a whole day, things of that nature. But when you have such a close temporal time where the houses are reasonably close to where this vehicle was and they were caught almost immediately afterwards, there's just not a whole lot of places that the defendant could merely abandon it. Instead had to intentionally conceal it from police officers, or the jury could find that. And so briefly, I'd like to touch on the aggravated assault just briefly. And I want to quote Mr. Anderson to prove that the state put on evidence that the defendant had a handgun and fired at Mr. Anderson. So Mr. Anderson, this is on page 43 of the record of the transcript. Mr. Anderson is asked, who was driving the silver Altima? And Mr. Anderson responded, the defendant. And there was a question, did he fire at you? Yes, sir. From his car? Yes, sir. At you, question mark, he fired. So there is clear and concise proof from Mr. Anderson that the defendant had a handgun and fired at him. And when we're looking at the questions of, who had a gun and who shot first, Mr. Anderson also testified that the defendant shot at him first. He did not stop his car until after he had been shot at. And so this 33-second video that we have shows him coming to a stop. And then it is somewhat unclear. It is open to interpretation as to who even shoots first from that time after the car is stopped. But certainly the jury was entitled to credit Mr. Anderson's testimony that he was shot at before he ever came to a stop. And so the evidence overwhelmingly supports the aggravated assault conviction. I believe we've talked about the tampering with the evidence. If this court has any more questions about the sufficiency of tampering with the evidence, I'm happy to answer those. But I'd like to briefly and quickly turn to the jury instruction question. And it's important to note the defendant has conceded that they waived this issue and that it's up on plain error review. So the burden is on the defendant to prove that more likely than not, if there was a plain error, that it would have changed the jury's decision. And so I think it's important to note that, again, the state's theory is that the defendant was a principal actor in shooting at Mr. Anderson. And then after he began to flee the scene, he was a principal actor in concealing his handgun. And that's the theory that was presented at trial. In fact, that is the defense that the defendant put on in his closing argument was there's been no proof that the defendant ever had a handgun. And the record belies that. Mr. Anderson's testimony belies that. But that was the defense that was essentially asking the jury to discredit Mr. Anderson as to whether the defendant had a gun. And so because he was a principal actor in concealing his handgun, this instruction, there's no clear and unequivocal rule of law that was breached because the instruction wasn't necessary. He was not being held responsible for Mr. Manning's thing. He was held responsible for his own actions. Also, the defendant cannot establish that this was not waived for strategic or tactical reasons because, again, defense counsel focused on whether or not the defendant had a gun. That's what he had placed his bets on. And so he could have strategically chosen not to emphasize an alternative way that the defendant could have been convicted. And finally, it's not necessary to do substantial justice, specifically because of the proof that we established that the defendant had a gun and he concealed it. And so for those reasons, unless there are any further questions, state respectfully asks that this court affirm the judgments of the court below. Thank you.
Hearing no questions, thank you, General. You may proceed with your rebuttal argument.
Thank you, Your Honor. I just want to start by clarifying two factual points from the record. Counsel stated that Mr. Anderson was lawfully carrying that handgun, and that is not true. Mr. Anderson was under an order of protection at the time of this shooting that prohibited him from carrying weapons. So yes, he had a concealed carry permit, but he was in violation of that court order by having that handgun, and he admitted to that. Second, unfortunately, opening statements will not help the court. I just checked the record and they were not transcribed as part of it. We did not proceed under the theory that the state intentionally misled the defense in any way. Our position was that the defense assumed, and the trial court faulted the defense for doing this, but assumed that it was the vehicle, and then it turned out to be the at least one firearm. That was the issue with tampering. As to the tampering charge, Judge McMullen, I think you said it perfectly that the only difference between this case and Hawkins is that the police actually recovered the gun in Hawkins. The defendant in Hawkins left the scene. That was the whole point of discarding the gun, was that it made it easier for him to leave the scene after police had arrived. And he was arrested at, I believe, a friend's house not long thereafter. Here, Mr. Manning was at his own residence. Mr. Manning and Mr. Coplin were found at Mr. Manning's residence within 3 to 10 minutes of the shooting occurring. And counsel talked about the temporal proximity, and I think we're looking at it two different ways. When you have a 1 block radius of less than 100 yards and 3 to 10 minutes, it's a heck of a lot easier to abandon something than to conceal something in that short window of time, in that short distance. Counsel is implying that the defendants somehow had the time to conceal rather than the more logical inference from these precise facts that they merely had time to abandon. And again, we had the officers testifying that about the proximity here, that Mr. Manning's residence was 1 block over. It was the first house on the right next to the intersection where the shooting occurred, that it was less than 100 yards, and that they were there within 3 to 10 minutes where Mr. Manning and Mr. Coplin, as Judge McMullen pointed out, presented themselves immediately upon the police arriving at the house. And again, as for the search, there was no specific testimony about what parts of the house were searched, how hard they searched. And again, no testimony about that perimeter search or how thoroughly it was done or whether the officers retraced the routes that those vehicles took to get back to the alleyway behind Mr. Manning's residence. It's not a large area. It's not a large window of time. And therefore, our position is that no rational jury could have concluded that that was concealment rather than abandonment. And we would ask this court to reverse so that tampering convictions are not upheld on the mere absence of evidence in every case. Thank you, Your Honors.
I wish to thank both the defendants' counsel and state's counsel for their preparation and presentation of their arguments today. They were very well made and received. I want to congratulate all of us for at least making history today, being the first to ever use this platform. It feels awkward to me, but I heard everything. It felt really, really good to see you in the manner in which you were presented on this screen. And I thank you for participating. We will stand adjourned to the call of the next case, which will begin at 11 o'clock. Thank you.